Thank you, everybody. I acknowledge that we are here on Central Orient land. I acknowledge their ancestors and I acknowledge their spirits. I acknowledge all the important people here today, all the people from different mobs and First Nations across the territory and beyond. I also acknowledge that in the treaty process, I was given fantastic support by the Deputy Treaty Commissioner, Ursula Raymond, who will be speaking at the Darwin matching event to this one, and Tom Snowden, who is here but has stepped out, who is working in the Treaty Commission office. The paper which I'm going to give today is really in three parts. The first part is my assessment now of the treaty process that was undertaken. The second part is some observations about the treaty processes around Australia and what might be learned for the Northern Territory process. And the third part is questions that any of you might have from the floor. I really encourage you to think about any questions that you might have. I'm here to lend as much of the information I've gathered about these processes as I can to the Northern Territory process. Now, there's a little bit of a blurb about me there, and Ursula Raymond. My mob, the Wangan and Jagalingou people from central Queensland, we are the people of the Gundaloo, the emu. We're also the people of the Gappa, the native bee. That's my great grandfather country. So I come down that men's line the whole way from that place. I also am a native title holder of my grandmother's country, which is Cullalee country out in the southwest corner of Queensland. Goes over a little bit into New South Wales, Cullalee people. And they have that same law and custom that comes up through from the Flinders Ranges, same way as the Anyamutna and Yeri and Bangala people down that way, who I've had the fortune of working with. The last time I was in this room speaking to people was in 2017 when I was the senior counsel assisting the Dondale Royal Commission. And I had the task of cross-examining a number of people, including ministers of the government, and taking evidence from senior people in this community. And I have to say that process was a very difficult one personally. It's nothing compared to the hardship that those young people were put through. And it leaves an open wound for me in that I know that not enough has been done for young people in this place. I know that those recommendations haven't been properly followed, and it makes me sad. The other thing I should say is that I am currently one of the council, the senior counsel assisting the Yuruk Truth-Telling Commission in Victoria, and that's a royal commission undertaken in Victoria, which has been called for by the First Peoples Assembly of Victoria, and we have been going for a couple of years. I've had the opportunity on behalf of the Commission to ask questions and cross-examine the Commissioner for Police, the Minister for Police, the Attorney General, the Treaty Commissioner, and the Treaty Minister. And in the coming weeks, we will hear evidence from the Water Minister for Victoria on the banks of the Murray, where she can look them local people in the eye who've got no water rights. And we will hear from the Premier of Victoria at Corrindurk, the former mission where all the Victorian Koris were rounded up to. And so we will hear that evidence from the Premier at the end of April. These are big processes. These are the sorts of things that I hope to see happening here in the Territory one day. Because the truth must be told, and I'll come back to that later. Now, I acknowledge as well as all the elders and First Nations people here, I acknowledge the land councils under the Northern Territory Land Rights Act. I acknowledge the Attorney General and Minister for Treaty, who's not here at the moment, but he's heard me speak plenty of times, and the member for Mulka, Yinia Guyula, who I have been in communication with over many years now about the need for a treaty and the wavering approach that we've had to witness from the government. I also acknowledge the NT Government Treaty Director, Robert Pocock, and his team for having brought this event together today. We have had a very detailed discussion from Donna Odegaard in respect of the background of the history of treaties, I suppose. I simply make the observation that there is a long history of treaty advocacy in the Northern Territory, and it seems that the first formal call for a treaty came from the Larrakia people in 1972, and Donna spoke at some length about that. I gave a speech in Darwin last year for the Austin Ash lecture called the Austin Ash Oration. In that lecture, I referred people to some of the words that were used by the King's Council, who represented the applicants in Mlurpum and Nabelco, the men that challenged Nabelco. In representing them at the opening of the case, starting the case off and trying to explain the case to the judge, he said, "They believe that the land was given to them by their spirit ancestors, and that their own spirits came from the land and will return to it after their death. Their relationship with their land is therefore timeless and inextinguishable. It is far more real and significant in our submission than the ownership in fee simple, which is the highest right recognised in our normal system of land tenure." The challenge for us in the treaty landscape is how we reflect that deep attachment that we have and the responsibility that we have for our country and our mob in an agreement with people who don't really understand that. I was just telling someone a moment ago, I was in a court case recently where some elders were giving evidence, an elder was giving evidence. So I do a lot of court work, but in this court case, and the judge couldn't understand what we were saying. I was asking them a question about how law and custom work. And they were saying, well, this way, it goes like this, and this is what happens, and these are the things we have to take into account, and this is what happens. And the judge asked something, and we realised that the judge didn't understand what we were talking about. We both looked at each other and went, all right. We brought it right down to what in my mind I was saying, we're going baby talk here for this fella. And that's how we gave the rest of the evidence, just enough so that they could understand, and they didn't really get it then. And so we're in this place where we are talking about big, important, deep things to people who don't really understand it. And this treaty, this agreement, sits in the middle, trying to say, okay, well, they will respect us and we will respect them and their law, which is like paper thin. And it's very hard. It's very hard. And sometimes it means that they have a lot of trouble coming to the table because they don't really understand it. They don't want to understand it. What they want to understand is they came here and they built a bridge and they built a road and they built a pastoral station, and therefore they put the land to good use and, they're the bosses now. Anyway, I note that in 2018, the Barunga Agreement was entered into between the Northern Territory Government and the Aboriginal Land Councils. And I'll speak a bit more about that in a few moments. It was a very important agreement, and I'll come back to that. Then in 2019, Mick Dodson, formerly Professor Mick Dodson, was appointed as a Treaty Commissioner for the Northern Territory. It turned out that he was appointed before the legislation could be put in place, and it wasn't until a year later, in 2020, that the Treaty Commissioner Act for the Northern Territory came into place. It's a little bit peculiar because normally the legislation around a Treaty Commission talks about the Treaty Commission and not the Treaty Commissioner. This legislation was all directed at the Treaty Commissioner, even mentioned Mick Dodson in there. Anyway, that legislation came into being. And during that period when Mick was the Commissioner between 2019 and May, June 2021, he and the Northern Territory Treaty Commission staff did a huge amount of work in terms of consultation and work developing what eventually formed the final report. And it couldn't have been done without their contributions in terms of the work they did in consultation, but also the thought that they put into it. A lot of it informed what was put into the final report. So in December 21, I was appointed for a 6-month appointment, which is all they could do under the Treaty Commissioner Act. And that appointment finished in June 22 when the treaty final report was delivered to the Minister for Treaty, Selina Rubo. I drove down to Catherine to give it to her personally in her office. There, and it was tabled later that year. Now, I'll come to what was said, but we all know that I think it was the 29th, or it might have been the 30th of December, that the Northern Territory Treaty Commission was abolished. So now, I just want to talk for a moment about the Barunga Agreement that was entered into, because it is really important in setting the scene for the treaty discussion here in the Northern Territory. So it's an agreement between the Northern Territory Government and the Aboriginal Land Council. So it didn't include the Commonwealth. It could have, but it didn't. It was the Northern Territory Government. And my observation of it is that it was largely driven by the Chief Minister of the time, from the government's perspective, Michael Gunner, and that without his commitment to it, it wouldn't have happened. So the important part, from my perspective, of the Barunga Agreement is that is paragraph 6, which says it is agreed that A, Aboriginal people, the First Nations, were the prior owners and occupiers of the land, seas and waters that are now called the Northern Territory of Australia. B, the First Nations of the Northern Territory were self-governing in accordance with their traditional laws and customs. And that C, the First Nations peoples of the Northern Territory never ceded sovereignty of their lands, seas and waters. That is an agreement which has been signed by the Chief Minister of the Northern Territory on behalf of the whole of the Northern Territory Government. You should wave that around whenever you get the chance. They have already acknowledged that that sovereignty has never been ceded, and you mob were all self-governing before they arrived here. In other parts of Australia, they don't even acknowledge any of that yet. So you're one step ahead of many other mobs. I just want to talk about the Treaty Commission final report. You can find it. It's still on the government website. It's some 100 pages long. I can let you on a bit of inside information. In March 2022, so halfway through my 6-month period of appointment, I made the decision that we weren't going to publish a 400-page document, which was how it was looking at that stage, and we decided to bring it right back down to 100 pages at least, to make it a little bit more accessible so that people could read it. And we put a lot of things in annexures, but the main report was reduced to approximately 100 pages so that at least people could read it. Now, what did it say? Well, the recommendations contained in the final report were that the Treaty Commissioner Act be repealed, so that because it was an inappropriate piece of legislation in the first place. It was about the Treaty Commissioner rather than the office of the Commission. But it was important that, of course, if the Treaty Commissioner Act was going to be repealed, then a Treaty and Truth Commission Act be enacted to set up a Truth Commission to continue the work that was a Treaty and Truth Commission to continue the work that the Treaty Commissioner's office was already undertaking, and that as we know, hasn't happened. In fact, the Treaty Commissioners Act was repealed and there has been no replacement. And the Treaty Commission no longer exists. One of the tasks that we recommended that the new Treaty and Truth Commission undertake is to hold a First Nations forum for the Northern Territory. And that's because I understood that as the Treaty Commission and as the Treaty Commissioner, we had no mandate to make any of these decisions about what the treaty process looked like. All we could do was make recommendations, and it needed Territory Mob to make that decision. Okay, is this the way we want to go? Is this what we want? Is this what we want to do? And there hadn't to that date been that mandate to give that go-ahead. And so our view was that there needed to be a forum which got as broad a representation as possible to give it the go-ahead to the process. The second aspect of the role for the Treaty and Truth Commission was to be the formal recognition of First Nations. What they have in Canada, which makes their treaty processes a lot easier, particularly in British Columbia where they're going through new treaties now, is they have a band system that's been in existence for about 150 years. And they have councils and set up around the bands, and they've got a political structure that exists. We don't have that here. What we have across Australia are, in some places, statutory land councils, and what we have is prescribed bodies corporate under the Native Title Act. But in the Northern Territory, you don't have that sort of coverage for First Nations, and so in order to enable treaties to be entered into ultimately between First Nations and the government, there needed to be some process of formal recognition. We recommended, and that doesn't mean that these First Nations, recognised First Nations, would be in competition with the land councils. That was not the intention. The land councils have a statutory function looking after the land and the land trust. They have a very strong economic role now with their role in looking after the Aboriginal benefits account. But in terms of the local, political, cultural, spiritual, law responsibility, that belongs to the mob at that local place. And that, one thing's for certain, doesn't matter where you go, if you try and speak for anybody else's country, you get pulled up pretty quickly. And nobody's suggesting that happen here. So the other recommendation was that there be as a first step, a territory-wide agreement between the Northern Territory government and First Nations. And that territory-wide agreement would ensure that Aboriginal and Torres Strait Island people, in my opinion, this is what it'd have to do, and this is what I think is happening in Victoria. They're entering a statewide agreements now. They're in the process of negotiating them, and they'll have a justice component, I understand, and other components to their statewide agreements, which protect the rights of all Aboriginal and Torres Strait Island people in Victoria. And I think the same can be done here, that you protect the interest of all the people, such as Naomi, who live on this country. And what I was taught is, well, when people come to my country, I've got responsibility for them. I've got to look after them, make sure they're all right. And I think we have to embrace that and say, well, we have to make sure that everybody's looked after. And that can be done through the statewide agreements. The next recommendation that we made in the report is that First Nations be able to transition to First Nation government, and we saw that as a very very easy transition from the regional governments that currently exist, regional councils that exist in the Northern Territory. And we saw it as something that reflects something that came out in the consultation that very strongly. Everybody that Mick Dodson and the team spoke to were still upset about the way the community councils were removed here in the Northern Territory, and that people wanted greater control over their local existence. And so we think that one way of doing that is for a transition to First Nations governments. Now that could be seen as a replacing the regional governments in the areas where in the rural and remote areas, but in the cities that's just not going to work, and it would have to be then a fourth tier of government. So in Darwin you'd have the Larrakia First Nations government, for instance. The next recommendation that we made was that that negotiations needed to be undertaken by First Nations when it came to the First Nations agreements. So you do the territory-wide agreement first, then the First Nations agreements across the territory. But in those First Nations agreements, there needs to be not only the Northern Territory government, but the Commonwealth government, the Australian government at the table, because so much of what happens, particularly here in the Territory, is driven by federal government policy and federal government resources. In my view, it's unfair to make our mobs negotiate twice. We would end up spending the next 30 years negotiating if we had to negotiate twice. The other observation I'll make about the Northern Territory, which is peculiar to this place, is that as a territory, the Commonwealth Parliament can make any law with respect to this place that they want, and so a hostile Commonwealth government could come in and override anything that the territory government does, and this whole process has to be undertaken in the knowledge that there could be interference from Canberra. And so my view is that you set up the systems to make sure that it continues on with or without Canberra. Even if the the Commonwealth Government says, well, we're not recognising the treaties, you still keep building the First Nations that can exercise those rights. So on the 26th of July 2022, after the treaty report was delivered, the first Northern Territory Government response from the Honourable Selina Ubo, who was then the Minister for Treaties, said, "We confirm the Northern Territory Government's commitment for the continuation of the treaties process. We support the Treaty Commission's final report's vision for a two-step treaty process characterised by the creation of an overarching territory-wide treaty approach and subsequent individual treaties of First Nations." I just want to talk a little bit more about First Nations governments. I'll make some other comments and then we'll have a little bit of time for questions. The First Nations governments, it seems to me, can be established prior to entry into treaty negotiations. Rather than being an outcome of the treaty negotiations, it's a precursor. It's something that happens before the treaty negotiations are entered into. The reason for this is that First Nations governments in modern treaties that are happening around the world, we look particularly to British Columbia. Self-government is the likely outcome of all of those negotiations. Everybody wants self-government. And so if it's going to be the outcome of a 20-year process, why not do it now? Why wait for 20 years? The second reason is that there's no reason for delay. The third reason is that it will allow treaties then to be negotiated on a government-to-government basis. And there's real power in that you then have the resources of the government, the First Nations government, to enter into those treaty negotiations. You have a proper standing upon which to enter those negotiations, and it improves the position and the quality of the outcome, in my view. It ensures that First Nations are resourced and have the infrastructure to support the work. And as I've said, it's proposed that the First Nation government will replace regional councils in their respective areas. I've already covered the fourth tier. I just want to say something on truth-telling. The final report recommends that the Treaty Commissioner Act be replaced by a Treaty and Truth Commission Act. A Truth Commissioner should be appointed to hear and report upon injustices in the Northern Territory. The Truth Commissioner would initially focus on receiving and recording evidence of elders and people who need to give their evidence as a priority. But I think it needs to be more than that. It needs to look at the way in which people were dispossessed. It recommended the report also recommended that a First Nations forum be held within the next 12 months after the report was delivered, and that First Nations forum firstly endorse the treaty process if everybody's happy. Secondly, identify the model for some First Nations representative voice for the treaty process, and appoint a negotiation group to negotiate the statewide, territory-wide agreement. They're all big things to do. They're difficult things to do, and they take a lot of work. But these are the things that we need to do, in my view, to shore up our side, your side of this. There's one thing asking the government to get their house in order and get ready for these negotiations, but there's a lot of work to be done on this side to make sure you're all ready. So there are a few other comments I wanted to make, and there will be some time for some questions. If I can find my page here. There's a number of observations that I can make about the treaty processes. If I can get this thing to work for me. Firstly, these are agreements with governments. and they must be led and fully supported by the leader of the government. And I don't say this in any way disrespectful to brother here, Chansey. I take my hat off to him for pulling this forum together. I pay full respect to him for his commitment to the treaty process, but my observation comes from looking at what's happened around Australia. And the leader of the South Australian government, Malinowskis, is right behind the voice process. He's the one that gets up and defends it. He's the one that talks about it in the press. He's fully committed to it. In Victoria, the whole reason that Victoria is so advanced as it is, ready to start negotiation of this statewide agreement, is because of the backing of the former Premier Daniel Andrews. It wouldn't have happened without him. So the transition of leadership in Victoria from Daniel Andrews to the new Premier Jacinta Allen has been positive, but I don't think we'll get to see the true depth of her commitment until she gives evidence to the Yoorrook Justice Commission. We'll know whether she's really committed and locked into this. Because if you don't have the leader locked in, if you don't have the government pulling all the same way, it's too easy for the bureaucrats just to not do what they've got to do. It's too easy for the administrative government just to say, oh, well, yeah, we'll do that a bit later. It's too easy for people to dodge the hard questions. It takes a commitment from the government from the very top. And look, I'll say this much about the Territory. I didn't see that level of support from the Chief Minister's office following the resignation of Michael Gunner. I didn't see it. It might have been there, but I didn't see it. Having that support from the Chief Minister is also important when the really critical decision comes up for Northern Territory in terms of budgeting. The second big fight that you have in the Territory that they don't have in the same way in Victoria or Queensland or even South Australia is the cost of doing this properly. The last thing you would want to do is see this try and be done on a shoestring and end up with a second-rate process. It needs to be given the solemnity and respect that it deserves. It's an important process for the whole of the Territory. Secondly, as we've said in the recommendations, there must be an independent third party that drives the process. In Victoria, it was originally the Treaty Advancement Commissioner, Jill Gallagher, and now they have a body which is secured in legislation called the Treaty Authority. In Queensland, it will be the Treaty Commissioner. They've undertaken an advertisement and interviewed people, and I'm expecting an announcement of the new Treaty Commissioners in any day. And the New South Wales government is currently establishing its own Treaty Commission. It cannot be the case that government does the work of determining the directions of the treaty process in-house. And that's meant there's no disrespect to those here or in the government that do the work. I understand that they are doing everything they can to promote this process, but from the perspective of fairness and balance, it has to be driven by an independent body. Otherwise, how can the community have confidence that what is happening is something that is not just the direction of the government of the day? But I should say this as well: it can't be all our side either. We can't expect to set up all the rules ourselves. It's got to be a circumstance where we negotiate the rules with the government, and we have a body that fulfills that function, an independent body. Third, in my view, there still needs to be this territory-wide forum that I spoke of in the recommendations. That's as representative as possible of First Nation interests across the territory or whatever the jurisdiction. In Victoria, the First Peoples Assembly of Victoria has been the representative body and driving force on behalf of First Nations in that state. Establishing such a body will always have teething problems. It will always be difficult, but without it, it's my observation that it's too easy for government and for industry to undermine what I call the singularity of focus that is needed to get to a treaty or treaty process across the line. You have to be very focused on where you want to go to, or it's too easy to get distracted. And you need people who have that mandate and that role to undertake that. It goes without saying. Some of you will, many of you will already appreciate this, but I'll say it anyway. Treaties in what they call First Nations settler states, Australia, New Zealand, Canada, North America. Treaties in this space are treaties between sovereigns. It's a treaty between the state or territory or the federation, the Commonwealth governments, asserting sovereignty that they've acquired by invasion or the doctrine of discovery against our deep connection and ownership of our country, which we have to call sovereignty to fit in with the discussion. But that it's sovereigns to sovereign. That's what these treaties are about. It's about the transfer of power back from them, which they took away from us at a sovereign level. And so it's not for me to talk about other people's country, but in my view, it would be only the people from this place who can enter a treaty about this place. And only the Larrakia in respect of their country, if I can use that mob as an example. But as sovereigns, using whitefellow language, as sovereigns, if any mob wants to join in with other mobs to negotiate collectively, they can do that, as long as it's their decision and they're not forced to do it or coerced. As long as it's their decision, they can do that. But my fear is that without the focus of a single group to drive this at a territory-wide level, with some mandate coming up from the nations, it will be too easy to be knocked off its path and lose its direction. The fourth observation I'll make is that there must be support for First Nations nation building and governance capacity. In the United States, many of you will know this. I think we might hear about it from Carl in a later session. The University of Arizona has had in place for decades a centre called the Native Nations Institute. Some of you might have even been there. That place describes itself as the leading research, education and outreach organisation supporting nation rebuilding efforts of Indigenous people worldwide as they seek to strengthen their internal governance capacities and realise their own political, economic and community development objectives. There's nothing like the Native Nations Institute in Australia at the moment. We desperately need it, and this work of rebuilding ourselves so that we're able to operate according to law and custom, but in a way that doesn't bring us into trouble with the authorities, the mainstream government, is hard work that needs to be done. But it has to happen, and so I know that there's a couple of institutions, academic institutions, that are trying to figure out how to do this in Australia, but it hasn't happened yet, and it really needs to happen as a matter of urgency. The final thing I wanted to say about from my observation is that truth-telling is a necessity. If we didn't know that before the referendum, we know it now. Too few people in Australia understand the truth of our disposition. it happened to all of us. Before the British arrived, I like to think of it as we were all wealthy in all respects. We were spiritually, physically, culturally wealthy people, owners of our own lands and living according to systems which protected us and provided for our safety. But then when the British, but that wealth was directly tied to our lands and waters because that's where our identity derives from. But when the British arrived, our wealth was taken and given to squatters and pastoralists and settlers. And if the treaties are to be of any value, then the truth of our loss must be known and properly understood, and the governments must do everything that is reasonably possible to put us in a position we ought to have been in if they had acted lawfully, with humanity, and with any sort of dignity. These processes are all difficult. The processes take years and decades, years and decades. They require long-term commitment. But looking at you, mob, the people I've spoken to up here in the Territory, I have no doubt that you, the First Nations mobs of the Northern Territory, that you still have the fire in your belly and will keep stoking that fire until it is done. And I look forward to seeing your progress with the treaty process as it goes along. So thank you very much for listening to me, and I'm happy to take any questions.
Keep this side of the mic.